Greetings from the Toner Law Firm here in Garden City. Today we're going to talk a little bit about to refuse or not to refuse. Before engaging in this discussion, it's important to note that it's not an attorney's job to teach someone how to get away with drinking and driving or to facilitate drunk driving. DWIs result in many injuries and deaths across the state every year, across the country. And it's important not to drink and drive, to make that initial decision. What attorneys do is that we teach and advise on how to preserve your rights in the event that you are charged with a DWI. When should you hire a criminal defense attorney experienced in DWI if you pulled over? Well, the answer is obvious: as early as possible. If you have access to an attorney that night, if he happens to pick the phone up, or if the police officers give you an opportunity to call your attorney and ask for advice, it's best to get an attorney as soon as possible. An attorney will advise you and give you their best advice, given the information that's available to them at the time. So here's some just general parameters, assuming that these DWIs tend to occur late at night. Not always. 4 o'clock in the morning, 3 o'clock in the morning. Your attorney may be asleep. We do sleep from time to time. But the question is, should you refuse, and what should you refuse? So let's initially talk about what a DWI is. It's a misdemeanor charge. It's a criminal offense. It has consequences. It could result in jail, revocation of your driver's license, a criminal conviction. For the illegal immigrant, it could result in deportation, immigration proceedings, loss of a job. If the job requires you to be sober or requires you to refrain from any injurious practices. If you're on probation, it would result in a violation of probation. So there's serious consequences. And what do attorneys do on DWIs? Traditionally, we try to negotiate either a favorable plea or a favorable sentence that minimizes the consequences. Now, this job gets more and more difficult given the number of DWIs a person has. The avenues available to us for a first-time offender are not available for second and third, and the consequences and the sentences of the judges get a lot more serious over time. So let's talk about the first-time DWI. It's still a criminal offense. The defendant will plead not guilty to it, and the attorneys will often try to effectuate a reduction in the charge to something that's not criminal. It may be under the DWI statute, but it's not criminal. A DWI carries up to it carries a 6-month mandatory revocation of your license. Again, a criminal record, whereas an impaired is not a crime. It's a 15-day maximum. Very rarely does anyone go to jail on it, and it's a much better disposition. So if an attorney on your first offense couldn't work that out, that's an excellent disposition. That disposition, that plea bargain, is not always available for the driver who's been in an accident, or the driver that's refused the intoxilizer, or the driver that has a very, very high reading. So, attorneys look at these cases a lot differently. We look at them in terms of plea bargaining and sentencing bargaining. Can we make a deal on it? So that brings us full circle to whether you should refuse or not refuse. So on the first offense, if you've had a couple of beers, a couple of drinks, my advice would always be to take the test, because if you refuse, it's a mandatory revocation for a year. Whereas if you only had a few drinks, there's no accident, no exacerbating circumstances, you're going to be able to either plea bargain that case or work out a favorable sentence in most instances. So rather than risk the refusal, where a prosecutor will probably not plea bargain with you as a result of your refusal, I would take the test. Things get more complicated on the second offense, because oftentimes the prosecutor is not going to make you an offer anyway. It's your second offense. They're not going to reduce the charges. The question is, do you have a good case for trial? Do you want to have the expense of paying an attorney to try the case? DWIs often involve the hiring of a chemist to test the reliability of the people's evidence. Can you afford the expense of that? So, in most instances, a second-time DWI can be worked out as well, as long as there's no accident, there's no fatalities, driving on the sidewalk, excessive speeds. I'm not going to give you a particular speed, but, just by way of an example, somebody driving 90 miles an hour on the wrong side of the highway is able to get pulled over without an accident. They're not going to be afforded a right to plea bargain on the case, and you can understand why a judge might come down on that very hard because of the potential consequences of it. So when do you refuse? On the second DWI, the decision has to be made by an intoxicated person if you don't have access to an attorney. And the question really is whether you intend to try that case later on. And it's not really a decision that an intoxicated person can make. If you refuse the intoxilizer, they can use that refusal against you. So it's not, and there are other factors of DWIs. It's not just the test, as we'll go into. So, look, the second time, I still advise, unless there's extreme alcoholism, high reading, exacerbating circumstances such as an accident, fatality, injured person, something along those lines, or an excessive speed, I would recommend most of the time on the phone, not all, but most of the time, I would recommend taking that test. Now, the third DWI is a class in and itself. On the third DWI, it's a felony, not a misdemeanor. There's a potential for upstate jail time. Many of the judges on these cases in the counties of Nassau and Suffolk will recommend and will condition sentencing on some type of jail time. And this depends on the judge and depends on the circumstances of the case. I remember a time here in Nassau County where there was a judge putting everyone in jail on third-time DWIs, upstate New York, into a program that lasted 8 months. And if the person did well in the program, they could get out in less than a year. But this is the third-time DWI. So the question on a third-time DWI is, should you refuse the test? And my advice in most instances would be, yes, refuse the test, because what you want to do is limit the amount of evidence they're going to ultimately use against you in the event that you go to trial. So there's a caveat. You need to not just refuse the test, you need to refuse to give a statement. Police officer comes over the car, you roll your windows down, I smell alcohol, have you been drinking tonight? I'm not telling you to lie, I'm not telling you to ever lie or make something up, but you need to refuse to answer that. I'm not going to answer that question. I would like to speak to an attorney first. You're getting pulled over for a DWI, and they're going to go through their whole routine, and you're going to be arrested. So if you answer the question, you have an admission of DWI and drinking that will be used against you at trial. It doesn't require Miranda. You're not in custody. The statement is going to be used. They're also going to ask you to do some standardized field sobriety tests, the 9-step walk and turn, the one-legged stand, and the horizontal gaze nystagmus test, which is that pen that they hold up and they ask you to look at the tip while they move it back and forth. That is a test that you need to refuse on your third DWI. Also, they'll ask you to take a portable breath test. Now, if you know you've been drinking, if you know that you've been driving, and of course you have, taking that portable breath test is going to be enough for the officer to arrest you if he sees that there's a high reading on there, or a reading over 0.08 in New York. So you have to refuse that as well. And then ultimately you'll be brought down to the headquarters in Nassau County, or you'll be brought down to a state trooper barracks, and they will take an intoxilizer test, which is a more formal, more scientifically reliable test. And you need to refuse that as well. So the expression in DWI, particularly in the third case, the third time around, is refuse, refuse, refuse. It's not enough just to refuse the intoxilizer. And the reason for that is, if there's no statement to be used against you at trial. If there's no intoxilizer result, there's no result to be used against you at trial. If there's no standardized field sobriety test results because you've refused them, then there is no evidence of that at trial. So what we're arguing here is that we want to limit the amount of evidence that's used against you on the third DWI offense, where it is more likely that you're going to trial than not. Most people cannot afford to go to trial on a felony DWI. That's reality. So if you want to take the test, take your chances with the judge. That is always a possibility. You should consider that. Again, it's an intoxicated person making this decision. However, the person who has a career on Wall Street, or somebody who has a family and a mortgage, and we've had these cases, a doctor who's going to lose his license, a doctor who's going to lose his job, or a Wall Street professional, or a lawyer, we know in the beginning that case is on a collision course with trial. And imagine having, a statement admission to drinking 5 beers, positive signs of intoxication on the standardized field sobriety tests, a high reading on the portable breath test, and then of course a high reading on the intoxilizer. Not a great case for trial. And of course the officers are going to testify that you're intoxicated, that you have bloodshot eyes, you have alcohol in your breath, and other indications that are historically noted to be associated with intoxication. Slurred speech, staggering when you walk. It'll all be there. These are classical DWIs that you can prove without a reading. The officers are trained to recognize someone who's drunk or who's impaired. So that evidence, it makes it a very, very untriable case. So if it's your third time DWI, again, you should never drink and drive. But if you do, you need to limit that evidence. So every case is different. This advice is broad advice. I think most attorneys labor to give the type of advice, whether to take the test or not. I think it's very appropriate to take the test in the first instance, where it's a low reading, there's no high speeds, there's no accident. It affords your attorney to plea bargain that case down to something that you can live with later on. On the felony case where your job's at stake, I think it's important to refuse to make that case triable to go to trial later on with less evidence, and that's the name of the game. Is the less evidence, the better it is for your case. I'm James Toner. My office is in Garden City. If you or someone you know has been charged with DWI or other crime, please don't hesitate to give us a call.